Hi, I'm Brian Barreira, and welcome to our webinar today. We're talking about anything to do with sales of real estate by estates and trusts. I'm joined by Eric Correira, who's been with us before. Eric, introduce yourself.
Hi, my name is Eric Correira. I am a trust and estates attorney admitted to practice in Massachusetts, Rhode Island, and Florida. I think I do a lot of the same things as Brian, and I'm looking forward to talking a little bit and sharing some stories today.
Okay, so we're going to be talking about Massachusetts and Rhode Island. Eric practices in part in Rhode Island, so um, let's start with estate tax liens. When someone dies and owns an interest in real estate in Massachusetts, there's an automatic lien on the real estate. It's not recorded by anybody. It's not anything you can see. It's just known by real estate lawyers who deal with sales of real estate. So in order to get rid of the lien, you have to do one of two things. If the gross estate is over $1 million, you have to file an estate tax return, even if there's no estate tax due. Even if everything was, say, joint with your spouse, you have to file an estate tax return and get a lien release. Otherwise, if it's below $1 million for the gross estate, then you can do an affidavit and get rid of it. It's a self-serving affidavit because you're the one claiming it's worth under $1 million. These things need to get recorded in the chain of title so that you can move forward with any kind of sale. Anything to add there on Mass and how does it work in Rhode Island?
Well, in Rhode Island, it's similar. I mean, we have a different threshold. Actually, I just saw yesterday they updated the figure because it changes every year for inflation. So now in Rhode Island, a taxable estate has to have over $1.7 million to have to do an estate tax. So if you're over the 1.7, like Massachusetts being over $1 million, you have to do a full estate tax return. One thing that's different about Rhode Island is, unfortunately, there's no simple affidavit like we have in Massachusetts to just say, okay, we're less than 1.7. You still have to file an estate tax return and show the division of taxation that the estate is worth less than $1.7 million. So, which honestly can be a bit of a pain for people to have to go through that process, knowing all along that they're nowhere near the 1.7 figure. But that's the way that Rhode Island makes sure people are telling the truth, because you wonder sometimes with affidavits, there's no oversight. They just get filed. So you still have to do a return in Rhode Island, regardless of whether the estate's taxable or not.
Well, here we almost raised the limit to 2 million last year, and it probably will be up there. But we have, in this respect, we've been maybe the most stupid state in the country because we put it in at 1 million about 2 decades ago, and it stayed there. And with everything that's gone up in value, especially real estate, you would think that someone at the State House would have thought about raising it at some point. Hopefully it gets done this year.
I hope so.
So the
Well,
lien,
I guess building on that point, so then we get into what does this mean? I mean, we have now clients who have to, a millionaire is not what it used to be, right? So we have clients who maybe have a house and some modest savings, but they're over $1 million. So they have to deal with paying estate taxes if they don't have planning. And they have to, when they pass away, their family will have to deal with filing an estate tax return.
and I should mention also here that you don't have to be a resident of Mass. You just have to own real estate in Mass. If you're an out-of-state resident, you still have to file a Massachusetts estate tax return. Now, the estate tax will be a fraction of the total, and that fraction is based on how much the real estate in Massachusetts is worth compared to the total estate. But there's still a lien, and it lasts for 10 years. And interest and penalties start running after 9 months. So that's an important thing for people with real estate to know about after someone dies. Anything else on that topic? Okay,
No.
let's move on to sales by estates. if someone dies owning real estate in their own name, there needs to be a probate process. Either it's a probate process with a will or without a will. Without a will, there's laws, Massachusetts laws say who inherits on that ground. With a will, the will controls. The person in charge of the estate is known as a personal representative. Somebody has to petition to be in charge of the estate. You cannot even sign a purchase and sale agreement until someone is in charge of the estate. Then, if the will gives the power to sell, then the person can immediately sell. If the will does not give the power to sell, or if it's an estate without a will, known as an intestacy, then you got to get a license to sell from the probate court. And that's a pain in the neck. Eric, how does this work over in Rhode Island?
Basically, all the same way. I mean, the same terminologies used, the same process. So in Rhode Island, it's really almost identical.
When the law changed in Massachusetts, we put in place our version of the Uniform Probate Code. We were sold a bill of goods about how fast an estate could occur. I don't know how long it's taking in the county where you normally practice, but I've been hearing like it's taking maybe 2 months before the court systems are even docketing the papers that are sent to them, that they're just sitting somewhere and and nothing gets done. The process doesn't even get started on their end for about 2 months. That
Right.
more or less your experience?
In the county that I'm primarily in, no, they're fairly efficient, but it is in other counties in Massachusetts. I'm seeing the same thing. And then of course, when you're dealing with a real estate sale, we end up having everyone, the client, the buyer's agent, the buyer's attorney, the seller's agent, everyone's calling, asking us what we're doing or why nothing's happening. And the reality is it's pretty much out of our control. All we can do is file and follow up with the courts, but we can't make anyone do anything. So it can be frustrating.
I mean, they do push things along a bit on a license to sell. And if you know that you got it coming, often there's an offer and then there's a full purchase and sale agreement. You can start getting all the paperwork ready to go and be, battle ready once the agreement is signed and get it moving. Now, the problem that I recently had with trying to get a license to sell is it asks on the form, and you have to check one of these boxes, that you filed an estate tax affidavit or you have a lien release on the estate tax lien. Well, we didn't. You gotta, if you need to file an estate tax return, you gotta get all the information together before you can file the estate tax return or a version of it that gets you the lien release. But you need the release before they will even accept the filing for the petition for the license to sell. So it's almost the cart before the horse. I mean, they should have a third box that says, we will have it by the time the license is issued. But apparently the law says when you file, you have to provide this. So maybe there's a change in the law that's needed. You have any problems like that in Rhode Island?
Rhode Island, you can get a license without the return being filed, but so you could, in theory, you could get the license first and the release second. That is possible in Rhode Island, but
yeah. Well, another example of where Massachusetts is falling behind.
I mean, the one thing, if we're talking about the delays, Rhode Island does probate on a town by town basis instead of having a county-wide court system. So the good thing is in Rhode Island, once you're in court, it happens quickly. You actually will go like if it's a town, one day a month, there's a part-time judge that will hear all the probate matters. So if you have a license, you can just go on that day and you walk out with the license.
Wow.
The downside is the court only meets once a month. So you have to wait until the next hearing date to be able to, get what
Wow,
you need.
that's really part-time.
It is.
The
So
judge
all the
works one day
judges,
a month.
right? All the judges are lawyers for their day job, and they're part-time probate judges. The cities will meet. I think at least one city meets once a week, and some cities meet twice a week. But just a town with 20,000 people, there's one hearing a month. The judges will, if there's something like, because it's probate, so they deal with guardianships. I mean, if there's some sort of emergency situation, they'll have special hearings to deal with a crisis. But you're just run-of-the-mill probate matters, which a license to sell, some people may think it's a crisis, but it's not a real crisis. You have to wait till the next hearing date.
We had a buyer recently walk away one day, we got the license one day after. And they recognized that it was a down market. They had their excuse. They walked away. They wanted their deposit back.
Yeah.
But the typical agreement says that you have 30 days. You can extend for 30 days.
Right.
So we extended. So they arguably have lost their deposit.
Right.
So one more.
I guess on that note, I don't know what you do, but in addition to the standard language about having an additional 30 days to clear title, I'll usually have, if I see the PNS before it's signed, which I don't always, put language in to say that it's subject to obtaining a license or subject to probate court approval, just something to make clear to everyone that the time frame is the court's time frame.
Yeah, I had that in there. We had the right to extend. They just thought that the market had dropped and that the market had dropped more than their deposit, so that even if they lost the deposit, they didn't care.
Okay.
So one more quirk in Massachusetts is we have two types of real estate deeds. One is regular recorded, the registry of deeds, and then there's something called registered land with the land court. I don't know why we have two of them. I have a suspicion that when the land court has to deal with boundaries, land boundaries, it takes over that land forever, so that since it's already ruled, there will be no more disputes. But whatever the reason is, we have land court. And when there's a sale of real estate that is registered land, the land court in Boston has to sign off on the deed. You can have a power of sale in the will. You can have a license to sell. You can have all the authority, but the county land courts will not accept a deed unless it's signed off. So you got to get a copy, a certified copy of the certificate of title showing who owned the land. You got to get a lot of probate documents certified. Then you either have to drive into Boston to the land court and walk in, or they now have an online system where there'll be somebody there will be assigned. But you got to get them to sign off. They put a stamp on it and sign the deed that it's okay to record, and you can't go forward without it. We had one recently that dragged on and on and on. I mean, they wanted us to do something different or get something different. Then they reassigned it. We sent in the new thing that they wanted. And in the meantime, that lawyer who was assigned to the case was taken off and it got reassigned, and someone else started from scratch.
Right.
And that person wanted an extra thing.
Right.
It's like, it just went on and on. So that's another thing to worry about when you have a deed coming that has to go get recorded at a land court in Massachusetts.
Mhm.
And you haven't had that fun experience yet, you told me before.
No, I mean, usually I think it's because I don't know, on my end, maybe because I'm in more than one state, but So I don't do as much Massachusetts, it's a portion of the practice, but I think a lot of times I have the buyer's attorney maybe is the one that's dealing with those kinds of issues if I do have a land court sale from an estate. But in theory, it's there to protect people, but now everyone gets title insurance, so it's,
But
I don't know. I think it was something that way back when it was created, everybody thought it'd be a great idea, but there's costs to having your property in land court initially, and nobody wanted to do it. So most real estate is still on the registry side.
right. That's why it's uncommon, but I seem to be getting a lot of those. Maybe other lawyers are turning down these
I was gonna
cases.
say, maybe they're right. Send it to Brian.
Right. So another issue that happens after someone dies is we're dealing with a trust. Now we have a type of trust in Massachusetts that's not many states have. It's known as a nominee trust. In Illinois, I think they call it a land trust. It's a trust that's not a trust. It's a trust that's really a principal agent relationship. The trust says who the trustee is. It does not say who the beneficiary is. There's an unrecorded page that tells you who the beneficiary is. So often the unrecorded page is lost,
Right.
and, I mean, that's one of those things that people are constantly having to find. But a nominee trust requires the trustee to get the permission of the beneficiaries before selling. So there has to be a certificate done by the trustee that they have the authority to sell.
Right.
And if you can't get the beneficiaries to sell, then you can't do anything. Sometimes you have to terminate the trust.
Right. And I have a feeling, well, you see this a lot too. One of the issues there's a lot of issues, I think, with nominee trusts, but beyond missing schedules, what I see a lot is a schedule of beneficiaries, and there's people who have passed away. And there's the schedule is straightforward. We're just list names so that each of their interests, it's like having a deed that's tenants in common. So you find out, people think, well, we have a trust, we're all set, there's no probate. But then you find out, well, the schedule, you have individuals that their estates have to be probated in order to then act. Like, to your point, if they need permission from the beneficiaries and they're deceased, well, they have to do probate. So
Right. So when I used to do nominee trusts, there's no real reason to do them anymore. That was a way to get real estate into another trust without recording the other trust. That's why a lot of these were done. A lot of these would say that the beneficiary is the revocable trust or the irrevocable trust. So that was the link. Now we can just deed it directly to the other trust and file a certificate with the court, with the registry of deeds or the land court. So these nominee trusts sometimes say that any one beneficiary can terminate it. Sometimes it says you cannot do anything without the permission of everybody. So what if you get, 3 out of 4 agreeing to something? It's a standstill, and yet the trustee has no power to do anything, even rent. These are a mess. So if you see a nominee trust if you're a person who has a nominee trust, you really want to look into whether there's a better way. Because after death, since we're focusing more on what happens after death here in this webinar, the trustee steps in, and often everybody's ready to sell and they want their money, but you got to get permission. Anything like that in Rhode Island?
Rhode Island does not recognize nominee trusts. There's no statute that allows them, but I have seen them used in Rhode Island. I think sometimes you find Massachusetts attorneys who have taken their forms and decided that, if it works in Massachusetts, it should work anywhere. And actually, when I've seen it, the title companies will, I don't know, it doesn't create an issue. They still acknowledge them. So they're not, they just pop up once in a while, but it's not something that anyone in Rhode Island really should be doing at all. I think if you come across the wrong title company, it'll be a problem.
But it is a principal agency relationship. So it's, arguably it should work anywhere.
Right, that is
I
true.
mean,
That's true.
um, so other trusts, real trusts, not nominee trusts, often say that the trustee has the power to sell. So often in a real trust, the trustee has the ability to do things without getting permission. And that's why you usually have a trust, so someone can run the show. So then the trustee just certifies, I have the power, and you can sell.
Right, so a trust should, you avoid all the issues we talked about with probate court and land court. The one thing that even in a trust you still have to deal with, assuming it was the decedent's asset when they passed away, is the estate tax return piece of getting a return completed, or to get a discharge, or doing an affidavit to say there's less than $1 million. But at least the courts won't be involved, which sort of everything's more in your control. And I don't know about your experience, but I find that with the estate tax unit, they're fairly efficient at getting things back. They don't really slow things down.
Right, but the process is inefficient. You have to
Right,
do,
it's a reverse, right? I know.
you have to do a 1999 federal estate tax return to figure out what the state would have gotten on that return, off of that return, the credit for state death taxes. Then you take those numbers, you put them on a mass form. Now you can't just file the mass form, you have to go online. And then all the things you just put on that mass form, you have to plug into the site. So why are we doing the mass form?
I agree.
And then,
or why are we doing the federal form from 1990? Why isn't there just an updated form? It wouldn't be that complicated to do, but I don't know. Just sticking with it.
I don't know. I mean, it shows what little thought they put into this estate tax over the last 2 decades.
That's true.
So the good news about, since we have a little time here at the end, the good news about the estate tax is if the asset goes on the estate tax return, or would have been if you needed to do an estate tax return, such as when you're doing the affidavit, then you get a step up in basis. So that means any capital gains up to the date of death on your share went away. So sometimes it's better to not worry about the mass estate tax, because the step up in basis is worth more to the family.
Right. No, I agree. I think in the past, when people had to worry about federal estate taxes and state estate taxes, there was always this push toward moving things out of their names and avoiding estate taxes. But I think you're right. In a lot of situations, well, first of all, you always have to weigh the estate taxes versus the capital gains taxes. But in a lot of situations, the decision is, okay, we'll keep the asset and get a step up in basis. That's because the estate tax is going to be a lot less than the capital gains tax for a house that someone bought in 1960 and owned for their entire lifetime.
And I think we should point out also that a life estate is an interest in real estate. All right. I said before, if you own real estate, well, you can own it in different ways. It's not just having your name on the deed as the sole owner. You could be a joint tenant, in which case you'd get a proportionate step up in basis, proportionate to your share in the joint interest. If it's a life estate, you get a full step up because you have the right to live there. If you have another thing that I've done before, because I don't want to have a life estate usually, is a power of appointment, a limited power of appointment. That is the power that you can deed it away and keep the right to deed it to somebody else later on. Not to yourself, not to your spouse, but you can reserve that right. So I do that instead of a life estate in some cases, because I'm concerned that if a state recovery is ever expanded on Mass Health, that they might be able to go after not just the life estate, but the whole house. If somebody is deeded away because of their concern about nursing home care. There was a footnote in the Daily case that came out, I think, in 2017. It made me worry about that. And so liens are there. Liens are there if you're involved in a trust, if you have an interest in the trust. If you're the trustee of the nominee trust, and yet the kids are the owners behind the scenes on the unrecorded page, maybe there's a lien there. There should be a lien on your real estate if technically, if you were there.
Right.
Even if you give it away and stay there, even if it's not a written right, there's potentially an estate tax lien there.
I had a return once where exactly an individual had a taxable estate. He had at some point deeded where he lived, deeded a multifamily to his, as a four-family, to his daughter. He continued to live there, and the Department of Revenue, since they saw his address, was like, well, where, we got into that, like, where did he live? Did he own that? And it ended up being, you're right. If you will be treated as having a life estate, even if you don't have an actual deeded interest. That's what happened in that case. If you live there and aren't paying any rent, like you're not actually a tenant, you're just living there. They wanted to include the full value, so then I had to deal with the Department of Revenue of explaining, well, he only lived in one of 4 apartments, and what's the square footage, and then coming up with a number for what his portion was. But that is true. And actually, sometimes that could be, I don't know, if I would never rely on that as a planning technique, but you could see times when that would actually, I've had people come in who deeded their houses to their kids, passed away, and I said, well, we're going to say this is a life estate because you want to get a step up. If they actually qualify, it's in the Internal Revenue Code and the regs. So
the Internal Revenue Code doesn't say reserved life estate. It says retained. And you can retain it by an understanding or an agreement.
Right.
So,
I think and the regs have those examples in there. So.
Okay. So I think we covered everything to do with real estate, or, after someone dies, how to handle it, or many of the basics.
I think so. I think the moral of all this is to know that when someone passes away, even when there's planning in place, there's going to be things that have to be done. So, while there may be a desire to sell the real estate, you have to manage expectations about items that need to be completed before the day of the closing. Especially, I think, in the last few years where you saw a lot of cash deals and things, people trying to move quickly because of interest rates going up. I mean, whether you're on the seller side or the buyer side, just know that if it involves a decedent's estate or trust, it may not move as quickly as it might otherwise have. And it's not the lawyer's fault.
It's not. I mean, we had one during the early pandemic in York County, where it took many months to get a license to sell.
Oh, really?
I don't many. I mean,
in the midst of the pandemic, yeah,
maybe 6 to 9.
Okay.
We could never get anybody to do anything, and fortunately, the buyer hung in there.
Yep.
Well, thank you, Eric. Thank you everybody who attended. We'll see you some other time.
Okay.
Bye.
Thanks, Brian.